Well, thank you everyone for joining us. This is our webinar that we've done once in person in the past, and we called it Your Job as a Trustee. And this was to really just talk about sort of the other half of what we do here. Not only are we setting up people's estate plans, but we also assist in representing a trustee in usually settling someone's affairs. And so the purpose of having this webinar today is to kind of in your own mind, if you're doing your own estate plan and you're thinking, who should you name as a trustee, or you've already done it and you're thinking, does this really, make sense as far as who I've named? We'll kind of go over what are the tasks that a trustee would be faced with. Similarly, if you are named as a trustee or acting as a trustee, this is really for you to get educated on what does that mean to be a trustee for somebody else. And overall, we do have slides presenting today, and then we have a more detailed handout. And so I'll put those again in the chat for you to download. And so we'll be following closely on the slides. If you do have any questions, feel free to use the chat function of Zoom, and we will answer those, during the presentation. And we do expect to go for about an hour, maybe an hour 15 today. And then we'll stay on for answering questions. And if we don't get to your question, you can always just send us an email afterwards and we'll follow up directly with you. And this presentation is also being recorded. And so afterwards, we will be sending out a link to everyone to watch it again later. And if they want to forward it to their own trustee or executor, that would be great. So we'll go ahead and get started. Let me just put the slides one more time in the chat. Okay. All right. So of course, our disclaimer is we're just kind of giving general advice. Anything specific to your situation, we should definitely talk one-on-one about.
Hello, I'm Roberta Robinson. I'm the founder of Robinson and Wilson. You might notice a slight resemblance between me and Daniel because Daniel's my son. I'm very proud of him. I've been in practice now 45 years. I have to update my slide, and I've seen a lot of things happen. So I hope to give you maybe some wisdom from my experience. Our office is in Rancho Bernardo, California, and Daniel and I are both certified specialists by the California Bar in estate planning, trust, and probate law. In addition, I have another son and 5 wonderful grandchildren.
And yeah, if I didn't introduce myself, so my name is Daniel Wilson, and I also need to update my slides. So I'm in my 11th year of practice here at our firm. And so again, yeah, also a certified specialist in estate planning and received a master's of law in taxation. And right now I'm serving as the Rancho Bernardo Community Foundation president. So, try to be very involved in the community here. And for today, again, we're going over your role as a trustee. And so again, most people think we're just setting up estate plans for people. So wills, trusts, powers of attorney. But we see the other half of it. So this is where somebody could be alive and incapacitated. So they, we put all these documents together, and then over time, it kind of comes to fruition where somebody else needs to use these documents on your behalf. And so we will represent your trustee and agent in kind of taking over your affairs in your lifetime if you become incapacitated. And then also it would come up, more commonly people are thinking at my death. And so some of the terms we'll be using, mostly we talk about a trustee. Commonly people also think of this as their executor. Really, it's kind of the same role. And when we talk about a trustee, that's because they're acting on behalf of a trust. And overall, in estate planning, at least in California, we mostly use trusts to administer people's estates versus having an executor named in a will. And we'll talk about the difference between the two, but mostly we'll be referring to a trustee, which is really what people think of as their executor.
Well, your roadmap in acting as a trustee is our California Probate Code. There's a big section in the probate code called trust law. So we are talking about your responsibilities under the law. You are a fiduciary. What does that mean? You are to act for the benefit of others, not for yourself. I tell trustees you want to be squeaky clean. You have fiduciary duties, and we're going to be highlighting about 18 of those fiduciary duties today. So what if you breach your fiduciary duty? You can be sued personally for the damages that you have caused by not acting reasonably, even unintentionally. You have to know what to look for. And if you are sued personally, you could be responsible for the damages and your own attorney's fees. Don't assume that the trust is going to pay attorney's fees if you're not acting reasonably. So we want to see the road ahead. And it's like a driver's ed course, what we're going to do. We want to think about what can go wrong before it goes wrong. And during that first meeting where we're meeting with trustees, I say, let's look ahead. Let's look at everything. Are there conflicts? Are there problem assets? Let's think of everything that can go wrong. And you cringe. You don't want to think about what can go wrong, but that's what helps you prevent problems. And from 45 years of experience, it's better to prevent a problem or address potential problems right away before there is conflict and anger, because once that lizard brain takes over, beneficiaries won't be so agreeable to coming to a compromise. We're going to look at the trust documents, and I think we want to go to the next slide. All right, your first duty to administer the trust. You have to administer the trust according to the terms of the trust. It seems so obvious, but the attorney is going to say to you, make sure you have the final signed trust documents. Not what mom was planning to do and it didn't get signed. We want to see everything that was actually signed. You're looking for wills, codicils, that's a change to a will. You're looking for trust documents, amendments to trusts, restatements to trusts. And of course, if you're our client, we're going to admonish you. Make sure you've told your successor trustee where all these documents are. Who's the executor? Who's the trustee? We want to review those signed documents. And you're going to want to consult with a trust attorney. We work in a specialty area. We work full-time in this area, and it's really something to keep up with the law, the cases, and you'll see how many things we have to keep up with here. I represent many attorneys. I represent personal injury attorney, criminal attorneys, family law attorneys. They don't work in this field. And if I have problems in personal injury or criminal law, I hope not, family law, I will consult with them. You really have to use someone who's knowledgeable.
And so, yeah, typically when we're in the first meeting after maybe usually like a parent passes away, and we're dealing with the child or the successor trustee, really what we ask for is, please give us a list of the assets and liabilities to the best of your ability. Of course, it could take many months to gather all that information, but as early on as possible, you really want to get a sense of not only what are the assets, but how are they titled? Because if, again, we deal with trusts, if all of your assets are in the name of the trust, that's great. The trustee can immediately get access to those assets and can handle them as necessary. If there's accounts that have payable on death to them or transfer on death, that's great. They just pass really outside of the trust, and it goes, as soon as you have the death certificates, that just goes to the people that it's meant to go to. Same with like IRAs or annuities or life insurance. They have named beneficiaries on those accounts. Again, try to get us that information as quickly as possible, as early on as possible, and then we can make sure to facilitate the transfer of those assets. But what if you do end up where an account or property or asset is titled in the decedent's name individually at the time of their death? What happens to it? If it's not in the trust and it doesn't have a beneficiary to it, potentially it has to go through probate. And being in San Diego, the time of going through probate is, at least really a year, that we need to figure this out as early as possible. Unfortunately, we come to these situations where maybe, a client of ours set up their trust, we transfer their house and other assets into the trust, they go on living many, many years. At some point between the time they saw us and the time they passed away, they did a refi of their property. And, the rates were a lot lower, so everyone was doing refis the last couple of years. So we had many calls from our clients saying, what's the name of my trust? Is it revocable or irrevocable? So we know lots of people were doing refis the last couple of years. Sometimes when you do a refinance against your house, the lender wants to make sure that the loan is to a person and not to a trust. And so they'll take the property out of the trust for you. I mean, you're signing the documents, but with, you know, the piles of paperwork that you're going through, you may not realize it. They take the house out of the trust. It's just in your name. They do the refi. They don't always put the property back into the trust for you. And again, if you go on living and thinking the house is in the trust and it really wasn't at the time of your death, that house has to go through probate. And so we did all this fine estate planning for you and set you up, but the title of your assets really control what happens at the time of your death. And so for, you know, if you're looking for a takeaway from this specifically, is check title to your house. And the way you can do that is through your property tax bill, look at your bank account statements. And I know we do have a lot of financial advisors and CPAs and bankers with us today. So they're a great resource to really help you on checking title to your assets. And if something's not in the trust or doesn't have the right beneficiary to it, they'll help you in transferring that.
You have a duty of loyalty to the beneficiaries. You must do what is in their best interests, not what is in your best interests. You have to be the squeaky clean trustee. So how does this come up? Let's say we have a trustee that needs to sell a piece of real estate and they want to hire their friend, the broker, to handle it. Oh, we're back. In that case, you have to ask, are you really acting for the benefit of the beneficiaries or for yourself to throw some work to your friend? What if that person's not the best person to handle this kind of real estate? Maybe they don't know that area of the country. What if they don't have the experience to do it? So if you hire a friend and it winds up being a detriment, and it could be just a perceived detriment to the trust, you could be held liable for damages. You also have a duty of impartiality. Daniel, I think you're going to take over on that.
Yeah. And again, when we talk about these duties, who are they owed to? They're owed to the beneficiaries. So everyone else that's going to, you know, inherit from the trust or the estate, these are the duties that the trustee owes to them. And so I like to say there's no trust police that exist. Unless you're in court, then the court really is kind of the police in this situation. But overall, so one of the benefits of working with the trust is that it happens without court approval or supervision over everything, just because that is so expensive and it takes a long time to have them supervise the whole administration. And so again, when you're out of court, you're sort of held to all these standards of all these duties. And so one of them is this duty of impartiality. And so again, we're thinking you cannot, as the trustee, use your role kind of to the detriment of other beneficiaries. And so you have to have no favorite beneficiary, even if you're the child of the parent and you're also the trustee and a beneficiary. You can't use that to your advantage. You have to be completely independent of that role, of those two roles. In fact, even when we deal with the trustees ourselves, if they're also a beneficiary, we have them sign this conflict of interest letter saying they are aware that they are the trustee and the beneficiary. We represent them as a trustee. Potentially, if they have any claims as a beneficiary, we can't also represent them in that capacity because that role as the beneficiary could affect the other beneficiaries under the trust. And so we really have to show them that there's two separate roles that you could be taking on. And, you know, what does that mean? Typically, if you're going to be doing one thing, make it fair across all the beneficiaries. If someone's thinking of doing a distribution from the trust, we typically say, you know, even though one person, usually one child, maybe needs the money right now, maybe they're being supported by their parents, and it's going to happen through the trust eventually, that if you're going to give out, you know, maybe $5,000 to that person, give out $5,000 to everybody else that would be entitled to it. That way you're kind of showing that you're just being completely impartial. A very common example, especially in Southern California, is many times a parent will say, I would like my house to go to my son, and I still want to treat my son and daughter the same, so it's still 50-50 between them. But my son, he'll take the house, my daughter will get maybe cash or other assets, and so that's going to be a 50-50 split if it's $1 million house and then $1 million in cash. But what about when the son is the trustee and he's the one figuring out the value of the house? He would prefer something lower so his sister gets less cash, compared to the sister wanting a higher value because she would like the house to be worth more. So again, in those situations, we really have to be completely impartial among the beneficiaries and dealing with their role as the trustee and making sure that they're not taking that as an advantage. Similarly, if there's like an ongoing trust, on the slide we talk about income versus remainder beneficiaries. Many times people will set up these ongoing trusts that say, you know, all income pays out to my son for the rest of his life. Upon his death, the balance goes to his children. Or maybe it goes to my wife for the rest of her life, but upon her death, it goes to my children, which would be her stepchildren. If the wife is also the trustee of that situation, she would want to maybe draw down the principal of the trust so that there's less money going to her stepchildren at the time of her death. If she's also the trustee, again, be very aware that you have to be, again, impartial to not just the income beneficiaries, but also the remainder beneficiaries. And so again, it's a very tenuous role that you could take on.
Conflicts of interest. See, this guy's lining his pockets. So it's important to realize if there are conflicts of interest, and somehow these sneak up on you sometimes. So for instance, we could have a trustee and he says, oh, that beautiful Coronado condo that's part of this trust, I'm going to move into it for safekeeping so that there's somebody occupying the condo. Nope, you can't have the rent-free use of trust property. What about borrowing from the trust? I've had this where a trustee borrowed a huge amount of money from the trust and said, but I paid fair market interest for the loan. Well, that's a no-no. And if that trustee used the money and made a profit from it, all that profit belongs to the trust. These are conflicts of interest. And of course, if the trustee decides I will be the broker for the sale of real estate, I'm going to get the commission, that is a conflict of interest. The trustee really can only receive compensation for their services as trustee. Anything past that is a problem. And then sometimes we have many times, there's been a loan. Maybe dad loaned money to the son who's now the trustee. Well, that son has to make it known to everyone that he still owes money back to the trust, not hide it.
And there's also a question in the chat, or the Q&A, that brings up a very good point. So when we talk about hiring or naming a trustee, so far we've really been talking about what if it's your child as the trustee, just because most common that's what people do, but it doesn't have to be. You could have a friend or a different family member, or there are what are called professional trustees or a professional fiduciary that exists. And it is a whole career that someone has chosen because they're licensed and certified and bonded and insured by the state to say, I will act as a trustee for somebody else. They follow all these duties, they follow the terms of the trust, and they will take on the role of handling all these things for you. So either you don't have someone in your family, friends, circle that would be willing, or that you feel comfortable naming or would be willing to act, you could have a professional trustee. And there's lots and lots of them, and you can interview them and talk to them and figure out what their fees are and what their services would be like. And sometimes people will still, even in their own documents, maybe name a child and maybe the professional as a backup. So they say, I would like my child to do it, but if for whatever reason, either they're not in the state anymore at the time of my death, or they're too busy with their own life, or it just is going to create too much conflict between them and the other beneficiaries, usually their siblings, they could just decline to act, and then the professional can step in. So there's a whole field of professional trustees that exists. And that, in a way, kind of brings up on the next slide. Another trustee duty is not to require a release of liability. So this comes up every so often when we're kind of finalizing a trust administration, and it's now time to distribute the assets to the beneficiaries. We tell the trustee, let's do the distribution, and we would also like the beneficiaries to sign their receipt and indemnify you as the trustee from liability. So we want them to say, voluntarily, I release you from liability. Everything you did was just great, and I'm not going to sue you for anything that you've done as the trustee. And so many times, unfortunately, the trustee will say, well, let's just have them sign that before we do a distribution. I don't want them getting a lot of money and then not signing the release and then coming back to sue me with all that money they got from the trust. Unfortunately, you can ask for a voluntary waiver or release of liability, but you can't require it as a condition for distribution. And so that's written into the law because it's probably come up so often. And so we have to remind our clients that you can't make this a condition on receiving the distribution. However, if you really are concerned that maybe a beneficiary is going to get upset at you, now it's time to do the distribution, where 6 months or a year later after the death, and maybe the relationship fell apart or it just became adversarial, the trustee does have the ability to go to court and then say, this is everything that's happened during this period of administration, and you submit an accounting, and you tell the court everything that happened. They give you a hearing date. If anyone wants to contest this matter and the plan of distribution, they would have to come forward at the hearing date. If not, and the court approves it, well, then you really are protected from anyone coming at you later on, because once you get that court order, that really does solidify the whole plan. So whether or not they're willing to sign the release doesn't matter anymore if you get that court order. And again, speaking of these professional trustees, sometimes they'll say that, either you sign this release and waiver of, my liability, or I am going to go to court for approval, just because, again, they can't put up with every single trust that they're administering, having it linger on, sort of sometimes like 6 months up to like 3 years before knowing that it's fully closed and that no one can come after them later on. And in any event, even when you do these distributions, we always remind the trustees, you still want to hold on to a reserve of funds to pay for expenses. Typically, it's like accountant fees and any tax liability, but also if you're needing to, protect the trust from it being any contests or, anything going to court, and you have more attorney's fees, you don't want to distribute all the money and have nothing left to use to defend those actions.
There's a duty not to serve as trustee of an adverse trust. Well, what does that mean? It could be that there are two trusts. One trust might be, let's pick on the husband who died. His trust is going to support his wife for the rest of her life. And after she's died, it goes to his kids. Her trust is her trust. And after she dies, it goes to her kids. We have different beneficiaries, and yet you've been asked to be the trustee of both trusts. So you need to look through the trusts, actually see through them. Who are the beneficiaries, and do they potentially have conflicting interests? And are you going to get in hot water because you can't keep everybody happy? In that case, you've got to decide, is this something I can manage? What could come up? Maybe there's a co-owned home, and one side wants to sell and the other side wants to hold on to the home. California real estate. Can you actually act impartially and prevent conflict in this situation? Or should you decline to act as trustee of one of the trusts and maybe as both of the trusts? So you want to think about this before you start your job.
Okay, and now the next couple of slides we have are dedicated to this duty to control and preserve the trust property. And so this is really one of the first steps, and sometimes takes the longest for the trustee when they're taking over to get everything under their control. And so we call this marshaling the assets. So again, this could happen in someone's lifetime if the trustee is now taking action because the person became incapacitated. Or it could also happen at death. So if the creator of the trust has died, the trustee now needs to step in. They have to get everything under their control as the kind of the very first steps. So how do they do that? For one, you really have to wait until you get the death certificates. So that's really the first step in the first document that really triggers everything is the death certificate, which can take like 10 to 14 days after the date of death. The mortuary typically orders it for you. And once you have all the death certificates, you can now start contacting all the financial institutions, any of the bills that have been, being paid, like invoices that have sent out for all these vendors, you can contact them. And again, everything really hinges on getting the death certificate. And so that's where we really, when we contact, or when the trustees contact us for the first time, after a death, we give them this list to say, fill out this worksheet of assets and liabilities. And again, get list of the title to the accounts, who's the owner, are certain things payable on death, or are assets passing outside of the trust, like a retirement plan, annuity, life insurance, sometimes even like a joint account. Many parents will add a child onto the joint account just for emergency purposes. And then if in the event of the parent dies, their name goes off of title to the account and it stays with the child or the remaining joint owner. So again, all of this, they have to sort of figure out kind of as the first steps is getting everything under their control. What else do they have to do is they really have to get valuations on everything on all of the assets. So we want a date of death snapshot of the values of all of those assets. Again, even if it's passing outside of the trust, it's helpful to know for tax purposes and otherwise, what are the value of all of the assets as of the date of death. And so with real estate, you can get we call it like a broker's price opinion letter, or just a realtor's letter saying, based on this value of the comparable sales in the neighborhood and the condition of the property, I would say the value is this amount. And typically they would attach the comparables to the property or to the valuation. And similar for bank accounts and investment accounts, date of death value of cash is pretty easy to figure out. But on investments, you want the brokerage firm to kind of reflect what was the value of these accounts as of the date of death. And typically, for tax purposes, this also allows whoever's receiving the assets to get the adjusted cost basis. So this is commonly what we call a stepped up basis. And so this would happen with your real estate, your investments, mostly everything else that's not within a retirement plan will get a new cost basis. And without getting into that too much, that really helps if the plan is to sell these assets after your death. You get whatever it was worth on the date of your death. Doesn't matter what the cost basis was because it gets adjusted equal to the date of death value. And so if your trustee is liquidating your estate after your death, likely they're not paying much, if any, tax on the sale because of that new cost basis. And if you are having like commercial property, or you're going to hold on, or the kids or the beneficiaries are going to hold on to your real estate after your death, typically we would recommend a formal appraisal of the property. So instead of just a broker's letter, an actual appraisal of the property. And that would be, again, for tax purposes, you want really a nice number to start off with. And a big deal also is dealing with insurance. And so this is one of the first things we caution these trustees about, is because you're dealing with a million little things. So, insurance is kind of a big little thing to overlook. So this is where, what's the homeowner's insurance on the house? Is the policy still enforceable even though the parent died? If they're not there anymore, does the policy just terminate? If not, how long does it go for? Typically you buy them in 6 months at a time, but did the policy happen to expire the day after the parent died and you never just kind of looked at it, or it didn't get renewed? And what if something happens to the house while you are acting as the trustee? Even if you're planning on selling the house, within a month after the parent dies, the house could burn down, there could be an electrical fire, something could happen. You as the trustee are liable. Even though you had all these other tasks to take care of and this was next on your list to do, doesn't matter. House burns down, insurance doesn't cover it. The beneficiaries are going to sue you personally for not maintaining adequate insurance on the home. And then we also are cautioning about vehicles. So what if there's the car that was in the decedent's name and they're not around, they're not driving it, so the trustee either drives it themselves, maybe they live out of town, or they let their child or niece and nephew drive it. We just call cars rolling liabilities. If somebody gets in an accident, doesn't matter who's the driver of the vehicle. A car accident lawyer is going to say, well, let's see who's got the deepest pockets. Is it the driver? Is it the person that's titled under the car? Is it the trustee? They're just going to look to see who can they sue. Maybe they're going to sue everybody. And again, maybe the auto insurance isn't going to cover it if the actual owner of the car died. So again, we're always cautioning our client or the trustee, if there's a car, just get it under your control. Don't let anyone drive it. And if anything, transfer title to whoever's going to get it as soon as possible. Sticking with this duty to control and preserve trust property. So we also let the clients know very early on that as the trustee, you're going to be tasked with filing the final income tax returns, doing a trust income tax return. If there's a probate estate, doing a probate estate income tax return. So these are all these different tasks that the trustee is going to have to take care of. And we always want to tell the trustee, you know, is this something that should be done before you distribute the funds? We've had situations where like the child or the trustee didn't know anything about their parents', you know, information or tax status or anything. And so they didn't even know if the parents were filing their taxes. And so we said, well, let's, you know, work with an accountant and figure it out. Were there back taxes that are owed, but don't distribute any funds, because potentially, trustee, if you distribute all the money and now the IRS is coming after you, you could be personally liable for distributing those funds. And unfortunately, that's the tough position of a trustee, because you're going to have the beneficiaries banging on your door, you know, as soon as mom or dad dies and saying, when are we going to get the money? Why is it taking so long? Again, people that don't know, have never done it before, they don't know how long it could take. And so in those situations, you really want to be careful as far as like filing these final tax returns, just so that you're not in the position where there's some taxes that are owed. We had a situation where a client died and he had a caregiver with him. And when you employ a caregiver to come to your home, you are treated as an employer. And there was some issues regarding the taxes. I think the original caregiving service contract ended. The client still wanted to have that person come to the house. So he employed her directly, probably was just either like paying cash or somebody reported something wrong. And now 2 years later, they're still trying to figure it out with the IRS. And so it's holding up this trust, you know, being able to be closed, because we kind of just don't know how long these, the tax liability, really how long it could take to resolve. Again, dealing with the IRS, especially with the last couple of years, every correspondence, every phone call just takes so long. All right, again, still all these tasks that you have. So you have to file or make sure if there's any estate tax returns that need to be filed after a death. And a lot of our clients now have assets, you know, nationwide. Are there any state estate tax returns? So if they own a vacation property in Montana or Florida or on the East Coast, those states may have you file a separate state estate tax return. And again, we're just our kind of lowly California lawyers. We don't have a state estate tax, but the other states do. And so we would recommend that you would work with an attorney in that state to advise you on something like that. And finally, property tax change of ownership forms. We never miss an opportunity to talk about property taxes when we're talking to our clients, because that's mostly, the largest asset of your estate, or kind of very high net worth clients have a lot of real estate in Southern California here. And so there's a lot of dealing with property taxes, and the Board of Equalization, who kind of administers property taxes, that we have to deal with. And those can be very tricky. And so we do, really recommend that you work with an attorney on these things. Finally, still me, a lot of talking. A lot of this information we kind of give to the trustee in this very initial meeting. One, to try not to scare them out of doing the job, but just to really impress upon them how much work there is going to be involved. And so we even tell them, you need to think about liquidity planning and cash flow. And so we tell usually whatever the plan has been as far as paying the person's expenses of mortgage, insurance, taxes, living expenses, all of that really changes when someone dies. And so you really have to look at the whole big picture of, if they had a whole bunch of assets kind of tied up in the stock market or something, does it make sense to liquidate it all now, keep some in there? What are the expenses of maintaining the home? Usually is kind of the big expense. Sometimes we're always concerned if there's a reverse mortgage on a property when someone dies. Typically that has to be paid back right away after the person dies, compared to like a traditional mortgage, which you can continue paying the payments and it's not going to be due on death. A reverse mortgage is due on death. And so typically those houses really have to be sold right away. And you could potentially be facing a foreclosure. And so again, there's a lot of things to think about when you're taking over as a trustee.
Thank you, Daniel. You had heavy lifting there. You covered so many things. What about the duty to make trust property productive? What does that mean? Well, let's say a parent dies and everything's being left outright to the children. You pretty much just want to wrap it up, get everything distributed. During the administration of the trust, though, you are responsible for what those investments are. And we'll talk quite a bit about that. Some trusts, though, go on. They're to be administered for the benefit of a spouse, a sister, a spendthrift, someone who doesn't know how to manage money, maybe someone with a disability. So during the administration of that trust, that beneficiary is called the income beneficiary. And it might go on for the rest of their life. And when they die, the trust is distributed to the remainder beneficiaries. Well, what does the income beneficiary want? They want you, the trustee, to produce as much income that can be distributed as possible. What does the remainder beneficiary want? They want you to grow the principal as much as possible so they'll get as much as they can get when the income beneficiary dies. So you see that there can be this internal conflict. And as trustee, you are supposed to act reasonably in balancing investing for income, which would be cash for interest, dividend paying stocks, for instance. And on the other hand, what about growth? What about holding raw land for future value? Well, you have to keep a balance between these two. We look to the trust to see, does the trust say anything such as prefer the income beneficiary over the remainder beneficiary? That's telling you go ahead and be more biased in favor of income. Is it something called a Q-tip trust for a surviving spouse, where a surviving spouse has the right to demand that you produce income? We really need to look at the trust. Typically, and we'll talk about this, the trustee every year reviews the trust investments to see what percentage is invested for income, what percentage is invested for growth, and adjusts it on an annual basis.
What are some more duties? So here we have our apples and oranges. So the trustee has a duty to keep the trust properties separate from their own. And so, in our world, it's very clear the delineation between like personal assets and like the trust assets. But I know for kind of many lay trustees, it sometimes just feels the same. It's this, they're in control over it. But it's very important that when you're acting as a trustee, everything that happens, your ownership of the accounts is still in the trust. So even though you're in charge of doing all the transactions and paying bills, the accounts are not really in your name, and they're definitely never under like your social security number or anything else like this. When someone dies, a trust gets its own tax ID number, or the trustee gets the tax ID number for the trust. So again, you just have to treat it like this entity that you're allowed to manage. And so how could this come up is sort of even accidentally, where many times, again, like I said before, if the parent adds a child onto a bank account and they're both joint owners on the account, that's great. If parent dies, technically it belongs to the child. So even if that was like the operating account that the parent had all their like rental income or social security or all these other monies going into, once the parent dies, the child can no longer do anything with that account on behalf of the trust. They could put that account into the trust and then use it, but they can no longer have any money coming from the trust into that account because it's a personal account at that time. And so it's very important when you're changing title to the accounts that everything is happening within a trust. So even checking, savings, investment accounts, if they were in mom or dad's name or in the trust, and now the trustee's taking over to put their name onto the account, it all stays under the title of the trust. And so that's why, again, with all our financial advisors that are watching today, we really appreciate you kind of keeping these trustees informed of this different role. Because we never want an account accidentally or on purpose put into their name personally. That would be a breach of trust. And if you're in front of a judge and they saw that you put an account in your name, I mean, that's the same as like stealing a car. It really is. They would not look favorably on something like that. And so be very careful, again, on filling out forms, or definitely with like joint accounts. And it's kind of a pain in the butt to have to do, but you just have to retitle all of the accounts, get new account numbers, new checks. Everything's just going to be kind of fresh when someone passes away and the trustee takes over.
A duty to enforce claims. This would be money is owing to the trust. How could this have happened? Well, maybe dad sold a piece of real estate while he was alive and is receiving payments on a note. Troubles sometimes come up where the note is from one of the children. So maybe dad loaned money to one of his sons and quite a bit of money is still owed back. The trustee needs to deal with that. So we have our imaginary case where Sonny owes his dad $200,000. Dad has 3 sons. The trust is supposed to be divided equally between the 3. Well, if Sonny's going to receive, I'll make it up, $1 million from the trust, one solution is he gets his $200,000 note back in the distribution. That means the note is extinguished and he gets $800,000 of other assets. But what if Sonny's note is more than his share of the trust? What are the possibilities? Well, the trustee needs to have a talk with Sonny. Are you going to pay it back to the trust? Let's get this over with, nice and clean. Everybody will receive their share outright. If it's more than your share of the trust, are the other beneficiaries willing to accept that you owe them money and you're going to keep paying your brothers after dad has died? That's not exactly an attractive solution because if Sonny defaults, his brothers have to sue Sonny. So, it's not really over with. So trustees, watch out for money that is owing back to the trust. Try to prevent conflicts. Daniel?
And on an aside, if you're alive and you've loaned money to your children or gifted them money,
yes,
just make it clear to everybody or to us. It happens, unfortunately, very often where, our client dies and then children come in here and depending on whether they got the money or not, they're either going to say, no, that was a gift, or no, they advanced it to my sibling or half sister or half brother, and that needs to be collected on. And, we just don't have a record of what was the plan. Was it a gift? Was it an advancement? Were they expecting to be paid back? Or how much money over the last decade was given out? So we can write that into the documents if you just tell us. Okay. So again, other duties. So the trustee has a duty to defend actions. And unfortunately, this is becoming a little bit more common these days that we're finding. People are living a lot longer. And sometimes, you're just putting yourself at risk for something to happen to you. A kind of common one would be like a car accident. But also, I said it earlier, what if you have a caregiver? So people are choosing to live in their homes, hiring caregivers. Again, you are the employer of the caregiver, even if you're going through a service. You have to have like a certain type of insurance. And again, dealing with like taxes and all of these things. So what if you die and the caregiver, is suing you for unpaid, money or something like that? The trustee has to defend these actions. So definitely, if there's any lawsuits that are occurring kind of in the person's lifetime, we tell the trustee, this really has to work its way out before we can distribute any of the funds. And so again, now we're thinking this could be like a year or 2 years. We have clients that are in the middle of divorce when they're going upon their death. And so we have to, work with like the family law attorney on finishing those matters. And so again, there's lots of attorneys potentially that they'd be dealing with. It could be civil, it could be a family law attorney. And so again, the trustee really has to keep, in mind that there's all these duties, which one of them potentially could be defending a lawsuit. And regarding like any general creditors that could exist, again, there's unfortunately many times where a child steps in and takes over the parents' finances at their death and really had no idea, did they have a lot of outstanding bills or taxes or all these other issues? And again, the goal of going with a trust is usually to avoid going to probate court. However, every trustee has the option of going to probate court specifically to notify any creditors or have them come forward to file a claim against the trust. So you're not opening up a full probate. You're just saying, I go to court, I publish notice in the paper, I give notice to all potential creditors. I collected my parents' mail for the last month, and I give notice to all of them. I don't know what is actually due. And then any general creditor can come forward, and then you just figure it out that way. But if no one comes forward or you settle any of those claims going through that notice to creditors process, you really are protected as the trustee from a creditor, 6 months later after all the money's gone, trying to sue you to say, you should have known about us, we sent you the bill, you didn't pay us, and now we're going to sue you to collect.
Your duty not to delegate, your duty to supervise. So in the middle of this picture, there's the trustee. And the trustee has hired many people, and the trust is allowed to hire people. Attorneys to explain what to do, financial planners to watch investments, property managers to handle real estate, CPAs to handle tax returns, but the buck stops with the trustee. You can't blame it on agents that you have hired that they have not performed to release you from liability. You are always liable for doing what you need to do or for failure to do what you need to do. So oftentimes a trustee says, well, my CPA was supposed to file the tax return. They're responsible for it. Well, the trustee is responsible for everything all the time. So when you delegate activities, you're really a project manager. You have to keep track of what everyone is working on. When is it due? Be ahead of the curve. Be the squeaky wheel that says, where's this? Where's that? When am I going to hear about this? That is your job. You must supervise. You will not be released from liability because one of your agents failed to do something. And there are many tax cases. We see these every year, tax cases that come up where could have been a CPA or an attorney who failed to file or make a certain election on a tax return. And the trustee is begging mercy that they tried to hire someone who was a professional to do it. And sometimes the IRS says, all right, we'll grant you some relief, maybe no penalty, but get it filed by here and there. But you don't want to be in those cases. You want to be ahead of the curve. Daniel.
Another duty, and these really are, these are all in the probate code. They're actually kind of like commandments where they say, you know, you shall do this or you may not do this. And so one of them is dealing with co-trustees. So if you've ever been in a meeting with us and you're thinking, oh, I'd like to name, you know, all 3 of my children or both of my kids as a co-trustee of my trust, you might have seen us, you know, take a big deep breath in and then just start telling you all these horror stories of what could happen with everything. And so that's kind of on the planning side. We'll talk about that in our meetings and our discussions. Does it make sense to have a co-trustee? But now we're thinking on the administration side, what if there are co-trustees that are named and are going to act? You know, what changes? Well, they have to do everything. They're liable for each other. Even if maybe one person is making like little small day-to-day decisions, paying bills, but they decide to sell the house together and all the terms of the sale, they're each responsible for what the other person is doing. And sometimes they're responsible for what the person is not doing. So again, if you just have one trustee that says, you take it over, you do whatever you want, I'll just sign off on whatever you say, that's great, it makes it efficient. But if that trustee that's doing all the work is, you know, does a breach of trust, the other trustee, even though they did nothing, they are responsible 100%. And so even regarding the fee of the compensation of the trustee, you know, they can't double the fee. So even if they're doing double the work, just because it takes 2 people to coordinate everything, they both don't get to double what a fee would be for a single trustee. And we'll talk about trustee fees later, but let's just say maybe the trustee is going to take 1% in administering the trust. If there's co-trustees and they split it, they get 0.5% each. They don't each get 1%. So that's something we have to advise these co-trustees on. And so we say if there's co-trustees, you're fully responsible for half the fee. So it's something to think about.
And here we have 2 brothers. One's a doctor and one is, I'm not sure. I might be politically incorrect here. So what we have is trustees that have different standards of care based on what skills they have. And who's going to be reviewing that in hindsight will be a judge in court. Always, it's, you know, that's what we're worried about. What is the judge going to say? So here we have co-trustees. And the buyer of mom's house is suing the trustee for not closing on time. And the buyer has all kinds of damages. Why didn't they close on time? Are these trustees liable for that? Well, the judge is going to listen to sympathy to the brother on the right who never reads contracts. The escrow documents were too long and confusing. He signed everything on his iPhone using DocuSign. He didn't read it, and he was playing Jimi Hendrix on the guitar. We had fun writing all these cases. But The one on the left, who is a professional, is going to be expected to have a higher standard of care. This is a person who's used to reading documents, being educated, knowing if they don't know something to find a trust or real estate attorney who's going to read it for them. That person has a special skill, and a judge is not going to have sympathy for that person. It's quite, black and white how a judge treats a lay person who does not have special skills from someone who the judges are unforgiving when they have even an attorney trustee. Well, that's a good one. You should have known. Don't even talk to me about it. So you have to use your skills that you have. Daniel.
Okay, so this is a biggie. And so the next couple of slides, it becomes a very big surprise to a lot of our clients if they're alive. And we get to this topic of the discussion, it's sometimes a surprise. But even at death, when we're dealing with a trustee, the fact that they have to be somewhat transparent to the beneficiaries comes as a surprise to them. And so one of your duties as the trustee is to keep beneficiaries reasonably informed. And there's some statutory language that what does that mean? One of them is that, let's say I create a trust and I die, my trust becomes irrevocable upon my death. Whoever I've named as my trustee, could be my son, he has a duty to notify all of my heirs and beneficiaries that I've died and that now there is this trust that exists. Again, whether or not they're in the will or in the trust or not, they could be getting nothing. They still have a right to be notified, and they have a right to receive a copy of the trust. And so this is a big deal that people think, trusts are private. No one gets to know what they look like. So that's true in your lifetime for the most part. But at your death, when it becomes irrevocable, your heirs and beneficiaries have a right to see the trust. And by sending out this notice, it does start a 120-day period for any beneficiary to contest the terms of the trust. So if they just don't like what the trust said, they thought they should get more, something is just written in there the way they don't want, and they have this kind of short window, relatively 4 months, to sue the trust or contest the trust. And again, it's by no actions as the trustee yet. We're just saying, what does the trust say? So typically, again, when we're working with the trustee, we say, send out these notifications right away. You want to get that clock ticking. And people say, well, can you just not do it or waive the requirement? And we say, even if everyone's going to get along, perfect. Still, let's just send it out. The time will run in the background and we could just take care of everything else while the clock is running. Otherwise, it's just kind of an infinite period of time when someone could object to the terms of the trust. The big deal is this new law that really just came out this year that says, even if you are alive, if you become incapacitated and the successor trustee takes over, that duty to notify starts then. So this is huge in the field of estate planning because, again, even as attorneys, we're very cautious. We never want any documents to go out to anyone. But again, so usually just at death is what we were used to, and we would actually send out these documents. But now the law says that even if the person's alive, even if I'm alive, if I'm incompetent, if I'm incapacitated, the successor trustee takes over, they have to send out a copy of the trust and that notification. The reasoning behind it is, since I'm the only one that could change the trust, if I lose capacity, I can no longer change the trust. It's treated as if it's irrevocable. So that's sort of the thought behind it. A planning opportunity is you could actually say the trustee does not have to send out a copy of the trust in those situations if it's written into your documents. So if your trust says, even if I'm incapacitated, don't follow this rule, this is just the default rule, you can go against it, you would have to write it into the trust. But this is a pretty big shift in the law and definitely a professional fiduciary. This is going to be a big deal for them to start giving out these trusts and sometimes inviting comment and stirring the pot with all these beneficiaries and heirs while the person is still alive. So again, like you didn't have enough to do already when you're taking over during incapacity, you now have to somewhat kind of inform the beneficiaries of what's going on. Not only that, what else do the beneficiaries have a right to know? They have a right to know, what are the assets of the trusts? How are they being managed? Did you sell something? Did you buy something? Did you get a fee? All of that goes on an accounting record that has to be given out over a certain period of time to the beneficiaries of the trust. So they would have a right to know sort of kind of when things get established. Generally, you have to respond to questions. Many times, like a professional trustee, or the best situation is where you have somebody that will just do like a monthly report. So every month, instead of having to wait for the beneficiaries to ask what's going on, you just say, I'll give out a monthly report, and it could be, you know, just in dialogue form or monologue form, or you do like a checklist of things that are going on, but you can give out a report to the beneficiary so they know what's going on and what's coming up next. Because many times the conflict that we see arises from these beneficiaries that just are kept out of the loop. And unfortunately for sort of a non-represented trustee, so if they decide to sort of do it themselves, many times they feel like, you know what, I'm the trustee, I have all the power, you just do what I say, or you'll get information when I give it to you. But that's not really the role of the trustee. They do have to be transparent, keep the beneficiaries informed, report to them, and definitely with the assets and everything of the trust, they have a duty to give it out, usually like on a quarterly basis when the trustee terminates. So it's a big deal to have to give out these accountings. And again, with the new law, not only do they have to give out this notification during the person's lifetime if they're alive and incapacitated, but they also have to start giving out these accounting records. So again, not only are your beneficiaries going to know potentially in your lifetime, you know, what does the trust say, they'll also get to know what are the assets and how are they being spent. So we just hate to think we always think worst case scenario is, you know, the trustee is doing a good job paying for mom's expenses. She has to go to skilled nursing or memory care, and it's $5,000, $10,000 a month. And you're having to give out this information to your siblings, and they're saying, why are you paying so much for mom's care? And shouldn't, you know, how about there's this place up in the desert that she can go live for half as much? And so unfortunately, those are the situations that we have to advise trustees on. And again, sometimes more the reason to have maybe a professional trustee involved is to not have that animosity from the siblings. And again, same thing though, the trustee can change that requirement. So in their documents, you could say, I don't like the idea of anyone knowing what does the trust say and what are the assets in my lifetime. I want you to write in there to say, trustee, don't follow that rule. Because again, that's just the default. If you don't say what they should do, is that they have to follow these rules.
Oh, this is one of my favorite slides. Okay, see that angry beneficiary who says, I want more. So let's take a look at discretionary powers. If you're the trustee holding a discretionary power, you must exercise it reasonably. So first thing you have to do is read the trust. Where are your powers in the trust? You could have a very long document that comes down to one paragraph that is your discretionary powers, and that paragraph is really critical. So for instance, a trust might say, the trustee must give all income to Nancy. Additionally, the trustee may give Nancy from principal amounts for reasonable health education, maintenance, and support, which we call a HEMS standard. Lawyers keep talking about HEMS, health education, maintenance, and support, in the discretion of the trustee. So mandatory income must be paid to Nancy, but discretionary principal. Well, first of all, you have to figure out what is the income, because income goes to Nancy, and that will be in the accounting. So you're going to have your interest, you're going to have dividends, you're going to have gross revenue from real estate, from which you're going to subtract all the real estate expenses to come down to net income. And finally, when that annual accounting is done, the CPA or the attorney or whoever's preparing the accounting will say, this is the net income number. Make sure that goes out to Nancy, and the trustee's going to write a check. Now, Nancy may say, but I need more money than income, and it's got to come from principal. So you have to decide, is it for health education, maintenance, and support? Really, literally, you're following that language. So let's have some test cases here. Nancy says, I need to put a new roof on my house. I need a distribution from that trust to put a new roof on my house. Trustee, you're going to say, I am not authorized to increase the value of your personally owned property, your individual assets. Is it for health education, maintenance, and support? No, I am going to improve one of your holdings. You can't have it. Nancy wants a vacation home in Mexico. Well, this was a real one. I have to have a vacation home in Mexico. And I said, you need to distinguish between what you want and what you need. And the trustee is like the ultimate parent. You know how it is to be a parent. You know, I've got to have the latest tennis shoes. Well, is that a want or is that a need? So you are to take care of the beneficiary's needs under that language. And then into the future, the beneficiary says, I want to go on SpaceX to Mars. Well, right now, that is not considered reasonable, but maybe in the future it will be reasonable. You're kind of bound by your times. And I'm watching here the passing of Queen Elizabeth and how the crown and the aristocracy lives. And it's not like most of us. And in determining what is reasonable, you're supposed to look at the beneficiary's customary standard of living. So if you're distributing money to a prince, it might include a trip to Mars, but not for the rest of us. And you need to keep a written record of your discretionary distributions. We have a little form we've created. What's the paragraph? What are your standards? Is it health, education, maintenance, and support? And then write a whole kind of dissertation on how much was paid out and why it falls within those categories. And when is that going to be looked at? Years from now, if it ever goes to court. And the judge is going to say, what were you thinking at the time? Because you need to be reasonable at the time you made the decision. So having this written contemporaneous record is really a critical piece of evidence.
All right, and we're getting to the end here. So again, once we finish our slides, we'll still take questions. So in the chat or the Q&A. And if you have to go, that's fine. You can log off. Again, we're recording this, so you'll get the recording to watch it later if you want. But feel free to, just fill up the Q&A in the chat with any questions, and we'll stay on as long as you like. All right. Next, trustee's duty is following their standard of care. And really, we're talking about regarding managing the assets and investments, they have to follow what's called the prudent investor rule. And so this is something that is written into the probate code that all trusts follow. And basically, it's saying that the trustee has to be very reasonable with the assets. And so this could be a big shift to a lot of people as far as like the assets go. Where in my own estate, if I want to put all my money in Google or Apple or Facebook or Meta, whatever, I can do that, or crypto. I can invest my money however I want. If it goes down, that's on me. If I die or become incapacitated, the successor trustee takes over, they better diversify those assets because now they're managing assets on behalf of somebody else. So it could be either me in my lifetime or the other beneficiaries at my death. But they can't just automatically keep those assets the same as they were in the person's lifetime. And so this is where, again, really working with a financial advisor can be a great benefit because they'll know, especially with the stepped up basis, does it make sense to change these investments? Should you liquidate the entire estate? What's the time horizon for holding on to these assets? Is it just going to be about like 4 or 6 months? Or is this going to go on for many, many years? Are you going to be investing for growth or for income? All of these things the trustee is tasked with following, and they're held, again, to this fiduciary standard of care. And so it doesn't matter if they're not familiar with managing assets or investments. They could be liable if the market crashes and they could have avoided it. Unfortunately, well, it comes up every so often, less and less these days, where we had a client that maybe worked for the same company, GE or Ford or something for their whole career, and they got stock options. And over the last 40 years, that's really what they've held on to. And it's almost, sometimes for people, it's almost like a family heirloom is the parents' stock. But again, if that composes like 90% of the assets of the estate, again, if that one stock, is so concentrated, if it goes down, the entire estate goes down. And to minimize, those kind of risk of liability or breach of your fiduciary duty, if all the family members are fine with holding on to the assets, we would actually have their consent. We would have them sign their consent saying, I understand that you have this duty to diversify, and definitely this block of stock would qualify, but we don't want you to do it. And that way, if something happens, the value goes down, that they can't sue you later on. But overall, typically we're advising the trustees, really take a look And you would think, most people are like these days, like 90+ years old when they pass away, that they would have something reasonable for a 90-year-old in their, investment portfolio, but not always. Sometimes people did their own investments and like to play the stock market and, found it fun. And so everything they have is very risky. And we tell the trustee, you better get out of that, maybe work with a financial advisor, find something less risky for the next 6 months or a year before you're going to distribute the assets. Sometimes trustees will just completely liquidate the entire estate, and then it's not even really an issue, just because they're kind of really shielding themselves from anything going wrong. But you couldn't do that if the plan is to keep this ongoing trust. You want to preserve what's there, not speculate as much as possible. But if inflation is making the value of the assets go down, then potentially that could be considered a breach.
The compensation of the trustee, a very important item. The trustee is actually going to compensate themselves from the trust, generally without court approval. So you have to take a look at what does the trust say about compensation. It might set a certain dollar amount. That's a little unusual, but sometimes that is the case. It might set a fixed percentage. It might say there is no compensation, and that's tough because look at the job of the trustee. Can you imagine how many hours this trustee has spent? Most trusts say reasonable compensation. So what is reasonable? It would be what a corporate or professional fiduciary would charge for the same services, which might run between 1% and 2% of the net value of the trust every year. The court really wants to know, what did you actually do for the trust? How did it benefit the trust? How many hours did you put in? So it's very important to keep a time diary. And if you have a special skill, let's say you're an engineer and you say, well, I spent 200 hours administering this trust and my hourly rate is X, so I should get this amount of money. The court would say, but you did not operate as an engineer being the trustee. Maybe if there was a house falling off a cliff and you had to talk to a structural engineer or what have you about the soil and doing something, yes, you were serving as an engineer. But to clean out the house and have an estate sale, it would be just what would be paid to a housekeeper, for instance. So it's very important to keep a diary of what did you do, when, what sort of service was it? And when we have to file estate tax returns and we want to deduct the compensation to the trustee as an expense of the estate, you better believe that we have to be able to substantiate that this was a reasonable fee, and we need good records.
And I'll note, we've had this situation come up a handful of times where, we tell the client, okay, reasonable trustee, and then maybe they go online and do some research, and they just type in like trustee fee or executor fee or California or something like that. Sometimes they'll see the probate fee. So this is a statutory fee that a probate executor is entitled to get if they go through probate court. That fee is going to be relatively higher than a trustee's fee. Again, there's a lot more formalities in going through probate. And so we've had clients say, look, this fee says I can take 5% of the estate, and that's what I'm going to take as my trustee fee. And we have to tell them, nope, that's a probate fee if you're going through probate. The trustee fee is completely different. So don't use that as an anchoring point. Again, depending on the assets, the trustee fee is going to be typically a lot less than what the probate fee is going to be. All right, well, you hung with us. So, what are we thinking for the takeaways on all of this? Again, kind of this comes up in different situations. This could be in your own estate plan, who you're going to name as your trustee executor. And does it make sense to have a family member? Are they going to seek, good advice? Typically, we say you just want somebody who's trustworthy and able to make good decisions. So they don't have to be, the one person that could do everything, but they have to hire the right people and listen to good advice. And, are they local? Are they not here? Would they be willing to do it? Consider naming a professional fiduciary, either in first in line or as a backup to the kids, just in case. So again, when we go through all these roles that the trustee takes on, hopefully it kind of doesn't make it more confusing to you, but kind of makes it clear as far as who would be best for this role. Similarly, on the other side of things, if you are the trustee, so you're named in the documents and it's time to act, it is a job So really be aware of all the tasks that you have ahead of you, the risk involved in being the trustee, the headache, having to put up with your siblings, or sometimes worse yet, their spouses, having them involved in all of this. And so it's something really early on, take really heed of whether or not you want to do it. So if you don't think you want to be the trustee, just don't do it. So you can decline to act. So before you're sort of halfway through and then you kind of regret it, it's better to just decline in the first place. And then hopefully at least the documents would say there's a backup. And really highly recommend working with an attorney on administering a trust. So that's our presentation. We thank you all for hanging out with us. We finished just about on time. So we'll go through the questions and chats, but feel free to log off if you have to go. And so let me just start early on. Title to a car. So Roberta, what do you think? Should somebody move the title of their car into their trust or just have it in their name?
Well, the title to a car can be transferred without probate. It's unbelievable. I saw Jay Leno with his collection of cars, and I kept thinking under California law, if that's all that's in his name, everything is in his trust, but he has these millions of dollars of cars. Well, the probate code says that 40 days after a death, the heir can come to the DMV with death certificates and transfer the cars to whoever it's going to without probate. So it's not absolutely necessary to put a car in a trust. It doesn't hurt, but there you have it.
Yeah. Other questions? One has to do, with airline miles and like hotel points, rewards points. What happens to those? Those could be very valuable. I know people love, paying our bill on credit card because they get some big points. So in that case, it really is dependent on each. It's a contract that you have with the company. So Wells Fargo, Bank of America, Marriott, whatever. It's a contract with them, or what are your rewards points and miles and everything. And so you have to look at the contract to see what happens upon my death. Are they transferable? Are they assignable? I know many times they do allow them to go between spouses, not always, but sometimes that's it. So you can't assign it to anyone to say at my death, this is who it goes to. You can't really put it into the trust. You would just have to contact the company themselves to see, what can I do with this at my death? So if anything, I don't know, use it before you lose it. Let's see. A question about homeowners insurance. So I'm glad you picked up on this. So should the agent be notified when someone has died? And does the policy need to be changed to vacant, unoccupied, or continued? Roberta, what do you think on that?
It's always good to be in touch with your insurance company and confirm, is everything covered? Is the trust an additional insured? How long is the insurance going to last? When does it need to be renewed? Some insurance companies say unless someone is living there, they will not renew the insurance. So be in touch with the insurance company.
Yeah. And let's see. Joint accounts. So this is a great question. So what happens with joint accounts? So let's say I have a joint account with my daughter and I have everything else in my trust. What happens with that account upon my death? Well, joint accounts, they're just treated as equal ownership. So even if it's with my wife, it's the same thing. Upon my death, the remaining owner is the sole owner of the account. So it doesn't automatically get put into the trust. It just belongs to whoever is still on title to the property or to the account. And so for that reason, I know many clients like to put their children on title to accounts. Usually, hopefully it's like a smaller one. And we'll just have these discussions with the child or the trustee saying, what do you think is supposed to happen with this account? Is it meant to belong to you? And then you used trust assets for all the other expenses. Do you plan on using this to pay for, funeral, hospital, and everything else? It's technically, legally, it is the child's account now. They can do whatever they want with it. So if that's how you want to have it set it up, just be aware that it really would belong to that child after your death. So many times we'll say maybe the big accounts keep in the trust and then like a smaller account outside of the trust jointly with that child or whoever your trustee is, just put their name on it. And if it ever gets low, just fund it from the big account. That way, if they end up walking away with that account, it's not going to be kind of the bigger assets. Let's see, a question, Roberta, about the notification by trustee. So can you opt out of that? So can you say in the documents, trustee, upon my death, don't send out this trust or any notification?
No, no, no. Nobody can opt out of the notification by trustee. And I know when this law passed, it was shocking to us estate planning attorneys that when someone dies, and now if they become incapacitated, we're having to inform beneficiaries about trust documents. What happened is that there was a lot of litigation starting years and years after somebody had died, and the judges got tired of seeing it because the attorneys have died, the people who are involved have died, all the witnesses are gone. So they finally said, just like in a probate, it's just like a probate, you must give a notification and beneficiaries have 4 months to contest. And I thought, this is horrible. Now I think it's a good thing because it takes the pressure off the trustee. The trustee can say, I've got 4 months, I can't distribute anything. Let's see, I've got to get things together, and the beneficiaries settle down. Of course, it means if someone has been omitted and they are upset about it, they can bring an action to contest the trust. And trustees, you need to remember, the notification covers contesting the way the trust was written. It does not cut off claims of beneficiaries that you have administered it incorrectly. Two separate questions.
Yeah. Let's see. So relationship between the trustee and the financial advisor on an investment account. So how does that work? So let's say I have my accounts at, I'll try to be neutral, Schwab, Fidelity, Vanguard, Wells Fargo advisors, whoever. I have my accounts with these financial institutions, and I have a financial advisor on the account. So that's sort of a personal relationship. I've selected them and I have my accounts over there. Upon my death, the trustee takes over, they get on title to my accounts. They can do whatever they want with those accounts. They could keep them there, work with the same financial advisor. They can move them to their own financial advisor or move them to their own institution. There's no restriction on what the trustee is allowed to do. And, you know, worst case scenario in some people's mind is they sever that relationship. You know, you pick somebody for 40 years that you worked with, and now they're going to work with somebody else. You know, that's a tough thing to think about, but they have the right to do it. So the trustee really has all those rights. The financial advisor really has to do whatever the trustee says. So if the trustee says, no, liquidate this entire account, the financial advisor said, doesn't matter what the relationship was with the client when they were alive, they just have to do whatever the trustee says. Let's see. Oh, here's a good one. So this is, you're probably going to get lots of different answers from different attorneys, but what about giving a copy of the trust to your successor trustee in your lifetime?
Are you asking me, the parent?
I'm asking you, yeah.
The parent, I'm worried, am I going to have problems that now my children are going to object to the way it was written? I'm not going to hear the end of it. Do I really want to give them copies of what I have? I do want my successor trustee to know I have a trust, where to find it, where do I keep my asset and liability information? Now, Daniel, as the child, what do you think about having a copy of the trust?
Well, we definitely kind of advise clients you may not want to do that. Just because if you change it in the future, there could be old documents that exist out there. Even if it's not to anyone's detriment, they could just be working off an old document. And so typically we tell the client, you know, maybe tell your trustee where you keep it. So you could say, if something happens to me, you look on this bookshelf and you'll see the book and it has all the documents in there. Sometimes the clients will give out like our card or our information and just say, you know, if there's something happens to me, contact my attorney, and we'll have, you know, the most up-to-date documents. Right, it just seems, because it's such a living document. They're called living trusts because you can change it whenever you want, as long as you have capacity up until the day you die. And so the concern would be, you know, we're always trying to minimize surprises. And what if you felt, you know, one way today, 5 years later, you made a change and you told your child or whoever about the old one, but not the new one. And then they see the new one and say, what about the old one? And it comes as a surprise. That could be a big deal. And unfortunately, you know, people are living longer and longer. Well, fortunately, people are living longer and longer. And so people will just change their trusts, you know, in their lifetime many, many times. Let's see. Who can contest an estate or a trust? So we talk about this notification. So it goes to your heirs and beneficiaries. So let's say I have 3 children, which I do. And let's say I've omitted one of them. So they're no longer a beneficiary, but they're still my heir. So they're, still a family member. But they're not going to get anything under the trust or my estate. So I say that in my trust. At the time of my death, the trustee, when they send out the notification, they still send it out to my 2 children who are heirs and beneficiaries, and that other child who's just an heir. And so they have, a right to see the trust and everything. And kind of from the recipient standpoint, you can kind of see that you wouldn't want just take somebody's word for it, that you're not included, and then just walk away. So you see the documents. And again, you can never stop anyone from contesting whether or not they're entitled to a copy of the trust or not, or anything. Somebody might just think, oh, my great uncle told me he was going to leave me everything, and he didn't, even though I'm not an heir if he, has kids of his own or something. But I'm still going to try to sue the trust or sue the trustee after they're gone to try to get what I'm entitled to. And so unfortunately, you can never stop anyone from suing. Let's see. But as far as who gets the notification, it's just your heirs and beneficiaries. Let's see. Okay, here's a very common question, Roberta. So how much can you have outside of the trust to avoid probate?
All right. So trusts avoid probate. What else avoids probate? The joint accounts. What else? Life insurance with a beneficiary, no probate. Retirement plans, no probate if it's payable to a beneficiary. So now we're just left with what was in the decedent's name all by themselves. And at that point, I'm going to check with you, Daniel. They keep changing the limit. I think it's $188,200 of assets.
Something like that, yeah.
Something like that can still be in the decedent's name. And 40 days after death, the trustee can actually contact the institution and say, I am the beneficiary through the will. It comes to me as trustee. I want to sign the small estate affidavit and have that account transferred into the trust. So they do have to wait 40 days, but it's a way to avoid probate on small estates, small probate estates.
Yeah, and a question about documents. So I'm glad we're thinking really practically here. But who has the documents? So in our office, we give the originals back to the client, no matter what. Doesn't matter what your parents told you or anything. We don't keep original documents. So we always give them back to the client. We do keep copies, of course. So anything that we've ever prepared or anything you've given us, we keep copies. We keep a paper copy and electronic copy just for safety. And then we give the originals and a copy back to the client typically. And we can even give the client an electronic copy themselves. And so, what happens if the client loses the documents? Hopefully, if they work with us, we'll have them and we can give them extra copies. And for the most part, copies are pretty much just as good as an original. The most important original document is the will. We call it the wet signature will, is the actual paper you signed. And why we have you sign with blue ink typically is so we can see the color and feel the indentation. So that's an important one to keep. But other than that, pretty much any copy would be acceptable at most, any financial institution or hospital for like healthcare directives. Let's see, a question about like a reverse mortgage. Right, so in the event of death, typically on a reverse mortgage, the house needs to be sold pretty quickly. They have a right, the lender has a right to immediately foreclose on the property. They don't want to, but they can. And so we always say, keep them well informed of the situation and the status and how long things are going to take. And if you're working with a realtor, you send them like the listing agreement. So it's really important that you, especially if the house isn't in a trust, that you really want to keep them informed, because again, going through probate to be allowed to sell the house alone can take like 4 to 6 months. So we've had the situation where it just took a long time to get the probate started, and the lender already like changed the locks on the property. So that was kind of a scary situation. Let's see. Oh, here's a good question. Incapacity, Roberto. So when is somebody considered incapacitated?
All right. So we look to the trust, because remember, that's the Bible, the trust. Some trusts say, if one doctor determines I'm incapacitated, that's it. And the successor trustee gets a physician's letter. It might say 2 doctors need to do it. It might say one of the doctors has to be a psychiatrist or a neurologist. So you have to do exactly what the trust says. And for the most part, these letters are accepted by institutions. It's very interesting. And then the trustee transfers title into their name as trustee. If the trust is silent, only a court can issue an order of incapacity and that the next trustee is to take over. And if we now have aging clients, it's amazing. I'm seeing 90 to 100-year-olds, sometimes over 100 on a regular basis. Like this is the year that was. It's just amazing. And in those cases, if there's someone with a declining mental, and sometimes they're not, they're as sharp as can be. I ask them, how do they stay alive? But if there's a declining situation, I might say, would you consider resigning as trustee so that no one has to get the doctor's letters or the court order? Or would you consider naming your son as a co-trustee right now with you so that you're on title to the trust accounts together?
Yeah. All right. Well, I think we'll stop there. If you still have questions, we didn't get to it or something else comes up, just call or email us. You have our information and we'll be able to talk to you about it. If anything we've talked about today really made you rethink your own estate plan or whether your parents should name you as the trustee in their estate plan, reach out to us or estate planning attorney and we'll be able to see if anything should be updated or fine-tuned overall. So again, thank you for staying with us today. And we look forward to see you at our next presentation, maybe in person or online again, we'll see. But thank you, everyone.
Thank you.